Hi. In today's lecture, we look at employment at will. This is the foundational doctrine that supports virtually all of employment law in the United States. And what the employment at will doctrine says, and it's one you probably have heard of, is that employers can terminate employees at any time with or without cause and with or without notice. This is the fundamental statement of employment law in the United States. Everything else in employment law is an exception to the employment at will doctrine. Now, the employment at will doctrine doesn't just protect employers, because at the same time, workers are free to quit their job for any reason, without notice or without cause. So if you are working at Chili's and you learn that Applebee's will pay you 50 cents more per hour, you can leave your lunch shift at Chili's and quit and go to Applebee's and work that night. No need to give notice, no need for there to be any cause for the change in employment. Now, there are numerous exceptions to employment at will, so I would advise you don't ever, when you are in business, be overly reliant on the idea of at-will employment. There are many exceptions, and here in Oklahoma, we especially have a number of exceptions to this doctrine, which sounds pretty straightforward, but which does not operate that way. So in today's lecture, we're going to look at the employment at will doctrine, and we'll examine its numerous exceptions that you should be familiar with. Now, employment at will, the doctrine, is rooted in another legal doctrine, a broader legal doctrine called freedom of contract. The idea being that the government should allow parties to enter into whatever contract they wish to enter into. Freedom of contract was an idea that took place, that really took hold in the United States during the years of the Industrial Revolution, with the idea that the best protector of a person's safety, productivity, salary, wages, the best protector of those was the ability to enter into a contract. Therefore, there was no need for a minimum wage law. There was no need for health and safety laws. There were no need for overtime laws. Instead, the focus was, if you don't want to work those hours or you don't want to work at that wage, then you are free to not contract with that employer and to contract with another employer who will pay you those wages. Of course, the freedom of contract doctrine has failed on numerous occasions, and so the story of 20th century employment law is essentially about creating federal statutes or state statutes to counterbalance the harm done by the freedom of contract doctrine. Now, the employment will doctrine says that most employment contracts can be terminated at any time. Now, the employment at will doctrine says employers may terminate employees even without cause, without incurring liability for breach of contract. The employment agreement, as we will see, is barely a contract, because there's not even a provision requiring good faith in dealing with an employment contract. These indefinite employment contracts constitute what we call terminable at will agreements. And again, this is the default nature. This is presumed. Employment at will is presumed in every employment agreement. To overcome that presumption, you must show one of the exceptions we're going to study in this lecture. Now, the classic restatement of the employment at will doctrine is that an employer can discharge an employee for good cause or bad cause or even no cause at all without being guilty of a breach of contract, without being liable for a breach of contract. So the at-will doctrine seems to be very broad, and it is repeatedly cited by courts. However, courts have also been willing to find a number of exceptions to employment at will. Now, before we talk about the exceptions, I do want to point out that employment at will is based on state law. There is no federal law regarding employment at will. It's all up to the states. States, however, differ in their approach to employment at will. Some states have very narrow exceptions, while other states have broader means to avoid the doctrine. So every state will differ in how serious it takes the employment at will doctrine. And as we'll see, Oklahoma is a state that has numerous exceptions to the employment at will doctrine. Montana is the only state that does not have at-will employment. In Montana, in most situations, an employer can terminate an employee only for cause, not any other reason. There must be good cause associated with the termination. But again, this is only in Montana. Now, the biggest exception to the at-will doctrine, and it's not really an exception because it is a contractual provision stating that the employee is not an at-will employee. Now, it could be in the form of an express employment contract, which is to say, in the contract itself, it can state the employee is not an at-will employee, or termination of the employment is only possible for good cause. So we could have that sort of contractual phrase. But more often what we see is a contract for a defined term. The contract itself may specify the duration of the employment, as well as other terms and conditions of employment and termination. So we see this a lot in, if you follow college football coaches. They will sign a contract, and the contract will be for 2 or 3 or 5 years at a time. This means the coach is not an at-will employee. The defined duration of the contract has taken it outside the scope of at-will employment, which means now the employer does owe an obligation to the employee to pay for the 5 years of the term. This is why coaches and schools often negotiated what they call buyout agreements. Well, the buyout agreement is simply a contractual clause providing that in the event the coach leaves or is terminated within a certain time period, then the school must pay a certain amount. Collective bargaining agreements, these are found in union workplaces. These agreements are negotiated by unions, and collective bargaining agreements generally require just cause for termination, which means that if you are covered by a collective bargaining agreement, you are probably not an at-will employee. Another form of the contract rule is what we call implied contracts, which is to say sometimes there may be a contract that seems to imply a status other than at will. Now, we often see this referenced in employee handbooks. This became a big thing during the latter years of the 20th century, and so what we saw at that time was quite often employers would include a waiver or provision in the contract that states you are an at-will employee. However, employees have been able to argue that provisions in an employee handbook may have created an implied contract. Now, most courts in the United States, most state courts have rejected this argument that an employee handbook somehow rises to the level of a contract outside the scope of employment. Nevertheless, Oklahoma has signaled that sometimes an employee handbook may rise to the level of an employment contract, even if the handbook contains an express disclaimer stating that it's not a contract. The Oklahoma Supreme Court has said, well, maybe we need to look beyond simply the language of the handbook. In this case, Russell versus Board of County Commissioners, it concerned a number of Sheriff Department deputies who were classified as at-will employees. The sheriff deputies sued the county for overtime wages based not on their employment agreement, but based on the employee handbook. Now, the handbook contained a disclaimer stating that the sheriff deputies were not employees, but instead were at-will employees. Nevertheless, the court said we need to look at the behavior of the county. Did the employer, in this case, the county, act as if they were subject to the handbook and not at-will employees? And that may make the difference. So employee handbooks, usually not a solid argument, but can be, especially in a state like Oklahoma, which has expressly recognized that employee handbooks can be viewed as implied employment contracts. There are also common law protections, so protections outside of the contract, protections that were created in a judicial setting by an appellate court. And the most important of these is what's called the public policy exception. The public policy exception says that if an employer terminates an employee who has done something that is good for public policy, then the employer may be liable for wrongful discharge. Now, it's tough to say exactly what public policy means, but essentially it means things that are good for the state, things that we want to encourage people to do. Oklahoma has a very strong public policy exception. In fact, a whole new tort was created in a case called Burke versus Kmart Corp. This was an Oklahoma Supreme Court decision in 1989. In this case, Ms. Burke, who was an employee of Kmart, alleged that her employer had terminated her because she had filed a sexual harassment lawsuit. Now, there are statutes that govern sexual harassment, and there are statutes that govern sexual harassment lawsuits and retaliation for filing those lawsuits. However, Ms. Burke had missed her opportunity to file one of those claims because, as we will discover, discrimination statutes have a very short statute of limitations. For most types of discrimination, there is a 6-month statute of limitations. After 6 months, you lose your right to bring that lawsuit. Well, tort law in Oklahoma has a 2-year statute of limitations. And so Ms. Burke brought a case saying that when she was terminated for reporting sexual harassment, that violated the public policy of the state of Oklahoma. And the Oklahoma Supreme Court agreed. In this case, the court said the at-will doctrine is not unlimited. There must be some provisions restricting the use of employment at will. And they suggested that in this case, doing something that violated the public policy of the state of Oklahoma violated this law they had created. Now, I should say that the Burke tort has subsequently been narrowed a great deal in Oklahoma, and recently an amendment to the Oklahoma Constitution was enacted stating that if there was a statutory claim available, then you did not have a right to bring a Burke tort claim. So the types of claims that we saw in Burke in terms of employment discrimination claims, wrongful discharge for reporting those, that is no longer available. However, it's still there in a way. And so the Burke tort, as an exception to the employment at will doctrine, lives on. Now, this raises the question, because, of course, is what is public policy? What rises to the level of public policy? Well, if you look at the legal definition, public policy is established when there is a law that is violated that protects the public from harm to their health or safety or welfare. There's a recent case out of the Oklahoma Supreme Court called Ho versus Tulsa Spine and Specialty Hospital. Now, this arose during the time of COVID. The governor of the state issued an executive order banning elective surgeries during COVID, meaning you could still have an emergency surgery, but you could not have an elective surgery where you pick the date and time of the surgery. Now, in this case, a nurse who worked at the Tulsa Spine and Specialty Hospital, Ms. Ho, refused to go to work because she alleged that her employer continued to do elective surgeries despite the executive order prohibiting them. The hospital argued that there was no legislative mandate, there was no law created by the legislature, and so that even if they did continue to perform elective surgeries, that did not mean that the governor's executive order rose to the level of public policy. The Oklahoma Supreme Court disagreed and said that even though it wasn't a law in the sense of a legislative policy, that when the governor speaks in this manner, in a way that is meant to protect health and safety, then that could rise to the level of public policy. Another type of exception to employment at will is called the breach of the implied covenant of good faith and fair dealing. Now, in every contract, there is an obligation of good faith. Whether it states that in the contract or not, there is an obligation of good faith. And so presumably, an agreement between an employer and an employee should include a promise that the parties are going to deal with each other fairly and in good faith. This is a presumed provision of virtually every contract. When you enter into a contract for the purchase of goods, even though you don't say so in the contract, the law presumes that both parties have promised to act in good faith. Well, this argument has had little success in state courts. Only a small number of states recognize the implied covenant of good faith and fair dealing in a employment contract, and it does not exist in Oklahoma. So good faith and fair dealing, breach of that implied covenant, probably not a winner in most states, not an exception to employment at will. Now, we mentioned implied contracts before in terms of employee handbooks. An implied contract arises out of the actions of the parties to the agreement. The employer's actions can create a reasonable expectation of continued employment. We saw this in the deputy sheriff case, wherein the court wanted to look at beyond simply the employee handbook, but look to see how has the employer behaved. Have they behaved as if there is a contract? In that case, we may state that there was an employee contract. And again, the employers can disclaim it. They can state to you, you are an at-will employee, but if they act as if you're not an at-will employee, they may not be able to later claim that you were an at-will employee. Another exception, one of these much more likely, is what's called promissory estoppel. Now, promissory estoppel is similar to implied contract, but it's not contractual in nature. Instead, the employee must show that the employer made a promise upon which the worker reasonably relied, to their detriment. So, for instance, there was a case involving a person hired to work at a company. He was a pharmacist. He interviewed for a new job with another company. They hired him. He said, well, I need 2 weeks in which to tell my employer that I am leaving. I need to give my 2 weeks notice. The second company says, fine, no problem. Well, a week went by. The second company decided they needed to hire someone right away, and so they hired the number 2 person on the list. Meanwhile, the original hire, the person who was giving notice, shows up at work 2 weeks later, and they tell him, your job is gone. Now, he doesn't get contractual damage. There's no way to calculate contractual damage. But instead, he gets what is known as promissory estoppel, which is to say, what were your reliance damages? How much did it cost because of your reliance on their process? There are also statutory exceptions to employment at will. The employer's ability to terminate a relationship may be limited by statute. And the best example of this has to do with anti-discrimination statutes. Again, we're going to discuss discrimination in the next lecture, but essentially anti-discrimination laws created a huge exception to employment at will, so as to say that yes, you can terminate an employee or refuse to hire a person for any reason, good reason, bad reason, or no reason at all, unless that is membership in a protected class, which means race, color, sex, national origin, religion, age, or disability. So anti-discrimination statutes constitute a huge exception to the employment at will doctrine. There's another law that we have not heard a lot about up until actually recently during the COVID era, and that's called the Worker Adjustment and Retraining Notification Act. This was a law passed back in the 1980s when manufacturing began to be shifted away from the United States to overseas, where manufacturers were outsourcing the production of the products. They would often close the factory in a small town that depended heavily on the factory. And so the government passed a law, Congress passed a law essentially saying you had to give 60-day notice in the event of any mass layoff. And so 60 days is guaranteed to you in the situation of a mass layoff. It's an exception to employment. And retaliation, there are a number of statutes that provide that an employer cannot terminate an employee in retaliation for exercising statutory rights. So if you file a sexual harassment claim, the law will protect you from being discharged. So it's an exception to the employment at will doctrine. Other federal statutes, there we see this, the False Claims Act. If you report that your employer is defrauding the government, then you can be protected from discharge. The Whistleblower Protection Act, many federal employees are protected if they report illegal or unethical conduct. A number of states have also passed whistleblower protection acts. A whistleblower is someone who reports or makes known publicly a situation at their employment. The FLSA protects against retaliation for reporting wage and hour violations. And then Sarbanes-Oxley protects whistleblowers for any publicly traded companies. And as I said, there are multiple state statutes. These state statutes differ from state to state, and so you'll have to look at the law of the state you're in order to determine whether there are whistleblower protections or not. Oklahoma, for instance, does not have whistleblower protection. So, in conclusion, what do we learn today? An employer can make any employment decision it wants as long as that decision is not based on a wrongful ground. The law presumes that employees are hired as at-will employees. And in recent years, the at-will doctrine has eroded as we have seen more common law protections put in place, primarily those having to do with public policy, as well as more statutory protection such as the anti-discrimination statutes. That's all for this one. Let me know if you have any questions, and I will see you in the next lecture. Thanks.